Assalamu alaikum dear viewers and dear students. In today's video we will discuss some of the remaining aspects of international law. We discussed about the sources of international law and what are the subjects of international law. Today we will be discussing about the jurisdiction of the states in the international law. So the word jurisdiction refers to the authority of the state to enforce its laws, the criminal laws and the regulatory laws. This is what we mean by the jurisdiction of the states. These jurisdictions of the states, they are usually extended, or they usually pertain to the territorial boundaries of the state, but in some cases they go beyond the territorial extent of the state as well. Now, what are the cases in which they go beyond the territorial extent of the state? For example, if a person has committed a crime in state A and the person is now residing in state B, so state A has got, if state A and state B has got an extradition treaty, then state A can ask state B to extradite that person to state A so that that person can be tried in the court of law of state A in which the crime has been committed. And if there is no extradition treaty between state A and state B, then what happens that there is rendition. The person is given to a third state and then he is tried on a neutral territory, which is neither the territory of state A nor the territory of state B, but it is some third state. So then that person is tried over there. Then again, what are those areas in which the jurisdiction of the state extend beyond its territory is some laws regarding the high seas. I'll be explaining that in more detail later on in this video. And then about the outer space. And what are the laws which extend in the high seas is that, if on international water a flagship of a state is sailing, the law of the state applies to that ship in which that ship is registered, and the law of any other state does not apply on that ship. So this is the extension of jurisdiction of a state beyond the territory of that particular state. The second important aspect is about the immunity of jurisdiction, immunity from the jurisdiction of a state. So in the first case, the jurisdiction of the state extended to a territory or an area outside the state, but in this immunity from jurisdiction means that if the citizens, particularly the diplomats of a state, if they are serving of state A, the diplomats of state A are serving in state B, so the law of state B will not be applicable on the diplomats of state A. I hope this point has been made clear, and if not, you can ask me in the question under the comment section under this video. So I'll respond to it, and I'm trying to elaborate it a bit more. That the diplomatic immunity about which we talk, that is immunity from jurisdiction of the host state. So all those states whose diplomats are working in other states, the law of other states does not apply, or the laws of other states do not apply on the diplomats or the officials working in the host states. Then we have the state immunity or sovereign immunity. That is also the same kind of a thing, that the diplomat who is working over there in another state is basically, he does not have this immunity as an individual, but since he has the authority of the home state behind him and he is a representative of the home state, that is why this sovereignty of the home state is honored and it is respected, and that is why this immunity is granted to the diplomatic staff. And if a diplomat is found in some sort of an activity which is considered detrimental to the interest of the host state by the host state authority, then that person is termed as persona non grata, and he or she or they are given a specific time period in which they can leave the host state. Recently, this has happened with some of the diplomats of Pakistan serving in India, and then reciprocally Pakistan also asked the same number of, or the same percentage of staff of India, diplomatic staff of India working in Pakistan, to leave Pakistan. So this is all about the immunity from the jurisdiction of the state. Then we have some statutes of international law which talk about the seas, the outer space, and some other areas, particularly the Antarctica. So what are the high seas? The high seas is basically that area of the sea which is not which is not part of the territorial water of any country. It is what we call international waters. So there are some laws of international waters. The first one is that no state may assert sovereignty over any other part or any part of the high sea. So in the high seas, which is 200 nautical miles beyond the territory of a state in the seas, so there the sovereignty cannot be claimed by any state. No state can claim that we have a sovereign right over these waters. It is for all. That is the first part of the first principle of the high seas according to the international law. Then what is the second principle of the high seas is that all states have the right to exercise the freedom of the seas, including what? Freedom of navigation, freedom of overflight over those seas, and freedom to lay submarine cables and pipelines. Now, and then the freedom to conduct or carry out marine scientific research as well. So these are some of the freedoms in the territorial sea, and every state having the ability can exercise all these rights, or can demand these rights for itself, and nobody would deny that legal entity these rights in the high sea. Then another very important aspect about the seas or the law of seas is that of exclusive economic zones. So in these exclusive economic zones, they are basically they are called the EEZ, exclusive economic zones. This is the short term or the abbreviation of EEZ is the abbreviation of exclusive economic zones. That is up to 200 nautical miles. So in this 200 nautical miles of sea, which is adjacent to the territory or the coastline of the host state of a state, over there, this country has got the right to exploit the resources of the sea for the benefit of for its own benefit. So this is the exclusive economic zone, and even economic activities can be carried out in these areas, like oil exploration can be done, other explorations can be done in these areas, because these are the exclusive economic zones of the countries, 200 nautical miles from the coastline. So these are the exclusive economic zones, and all sorts of economic activities can be carried out over there, and the resources in the seabed can also be exploited for the benefit of that country. Okay, and then we have the deep sea bed, which is beyond the limits of the national jurisdiction. So in these deep sea beds, they are under the high seas or the international waters. They are termed as the common heritage of the mankind. So all states have equal rights over those areas, and no state may claim or exercise sovereignty or the right or sovereign rights over any part of this sea or its resources, and it is governed by the International Seabed Authority, ISBA. So International Seabed Authority is governing these areas, these deep sea beds, deep sea bed area, and all states have got equal rights, but no state can exercise sovereign right over these areas. Then again, we have another very important aspect, and which is almost like the law of the sea, but that is not related to the sea, that is related to the outer space. And as in the high seas, no state can claim sovereignty in the high seas, it is similarly the case with the outer space. And there are some principles in the outer space. The first principle is that no state may assert sovereignty over any part of the outer state, like on the territory, on the high seas, or in the international waters. Over here in the outer space, no state can exercise sovereign right. The second is that all states have the freedom to use the outer space for peaceful purposes. So space cannot be used for military purposes. Like nuclear test cannot be carried out over there, other military expeditions, or it cannot be used for any military purpose. It can only be used for peaceful purposes. Then the next point is that states on whose registry a space object is launched shall retain jurisdiction and control over the space object and or any person on board that space object, which is a rocket, a space shuttle, or a space station. So the law of the country in which that object has been manufactured, the law of that country will govern that object, and all the personnel which are on board that object, the law of that state will govern them. So this is regarding the outer space. Now another very important point, and I would like you to think about it, and I would also try to go a bit slow about this important aspect, and that is about Antarctica, which is the seventh continent of the globe. And what happens that officially 7 countries initially they had a sovereign claim over Antarctica, or over several region over Antarctica. They had this sovereign claim. What are the names of those countries? That was Argentina, Australia, Chile, France, New Zealand, Norway, and the United Kingdom. So these are 7 countries. Let me repeat it for you. Argentina, Australia, Chile, France, New Zealand, Norway, and the United Kingdom. These were the 7 countries. Then an Admiral Byrd, on behalf of the United States of America, also claimed some of the area that it belongs to the United States of America, but the United States of America never officially endorsed his statement. So this was the official stance of the US. Then in 1959, the 7 claimant states which I just mentioned, those states along with 5 other states whose scientists had been conducting research in Antarctica. And the name of those 5 states are Belgium, Japan, South Africa, the United States, and the USSR. The then USSR, now the USSR has been disintegrated in 1991. So the then USSR, in 1959 they entered into an Antarctic Treaty. And now what did this Antarctic Treaty say? This Antarctic Treaty says that it basically froze all the claims of the 7 claimant states and stated that no new claims to sovereignty would be made over this territory or this continent. So in 1959 that issue has been settled, and now nobody claims sovereignty over any part of the Antarctica, and it is purely utilized for scientific research by the developed countries who can carry out scientific research over there. So the area of Antarctica is now basically specified for scientific research for the whole world, because these are like 7 and 5, these 12 were parties to that treaty, and the rest of the states, though they are not party to the treaty because they did not sign it, but they respect that treaty as well. So that is why no states go there and claim sovereignty over any part of Antarctica after 1959, after the Treaty of Antarctica. So that is all about these high seas, outer space, and Antarctica. These were the laws, international laws, which regulate the affairs of states in those areas: high seas, outer space, and Antarctica. Then again, what are the principles which govern the relations between different countries or different states or different international entities, you might call it? So, the general principles governing friendly relations between states are set out in the United Nations General Assembly Resolution 2625. The United Nations General Assembly Resolution 2625 talks about the principles governing friendly relations between different states, and there are some of the points about of this resolution which I'll be going through quickly. Number one, it says that states shall refrain in the international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any manner inconsistent with the purpose of the United Nations. Definitely the purpose of the United Nations is to maintain peace on the global level. So threat or use of force is against the territorial integrity of any state can threaten this global peace, and that is why no state should try to do so, or to commit any kind of act which can threaten the global peace. Then it talks about governing the friendly relations. So it talks about pacific settlements of dispute, like there should be no war or disputes. Disputes can be settled pacifically, peacefully. So this is the second principle of it. Then the non-intervention in matters within the domestic jurisdiction of any state in accordance with the Charter of the United Nations. So there is non-interference or non-intervention in the domestic affairs of any state. Then point number 4, or the next point, is cooperation with one another in accordance with the Charter of the United Nations. So if then they will have to go to the Charter of the United Nations and look what does cooperation mean, what are the principles of cooperation with each other, so they will have to abide by those laws or those principles. Then equal rights and self-determination of people. So all the people are equal, they have equal rights, and if a community wants to express its self-determination, so self-determination is the right of the people, like they can express this right and they can have a separate state for themselves if they this self-determination is the right. And that is why Pakistan is supporting the self-determination of the Kashmiri people and the Palestinian people and many other people which are suffering under any sort of occupation in the world. Then another principle, or principle number 5, is the sovereign equality of the states. So all states are sovereign, or equal sovereign, or sovereign equality is there. All states are equal sovereign. In other words, sovereign equality is there. Then point number 7 is that states shall fulfill in good faith the obligation assumed by them in accordance with the Charter. So whatever obligations the United Nations Charter has given the states, or whatever obligations they have assumed under this charter, they shall fulfill these obligations in good faith. Right? This good faith is important for it. Then another point is about the international law, which is also very important, that responsibility, what is the responsibility of a state or states for wrongful acts which have been committed by either the states or by some of its citizens. So then we have, as you remember in the previous lecture, I was talking about the International Law Commission. So the 2001 International Law Commission articles on the responsibility of which codifies this conventional law or customary law into a proper law. So this 2001 International Law Convention, International Law Commission ILC articles on the responsibility of the states for internationally wrongful acts sets out principles in this important field of international law. Now, what does it say? These articles have not been adopted, number one. they have not been adopted as an international convention, but they are still respected, and international courts and tribunals, their decisions, they refer to these conventions. So that is why they are important. Then it says the states are responsible to other states for their internationally wrongful acts. Now I'll be trying to explain because this is a bit technical, so I just want you to be with me so that you can understand this point, that states are responsible to other states for their internationally wrongful acts. Now, what is these acts of commission or omission? What are these acts? Number one, that is attributed to the state under the international law. So a wrongful act, if a state commits, and if it is attributed, I will come to this attributable part later on, but if it is attributable to the state under the international law, then international law would say that it is, this state has committed a wrongful, internationally wrongful act against another state. Then point number two is it constitutes a breach of an international, if it constitutes a breach of an international obligation owed by the state to the injured state or the international community. Like if a state has committed or if a state has committed an act which is considered as a breach of any treaty with another state, so or in with the international community, then that will also be termed as the wrongful act. So therefore, if a dispute arises between the two states, there will be two questions which will be arising out of that dispute. And what will be the question? The first question is whether the offending state owed an international obligation to the injured state under either a treaty or under customary law. So whether that state is in some kind of a treaty with the other state, and now this state has violated that treaty. This is the first question. As you remember that I was telling you that first of all, a treaty is looked into. If there is a treaty signed between the states, so then International Court of Justice decides the matter according to that treaty. So it is that matter now. And the second question which will arise is that whether that obligation was breached by conducting consisting of either an act or omission that is attributable to the offending state. Now I will explain this attribution part a bit. The rules of attribution are based on the common sense. This is part number one. The conduct of an organ of a state is attributable to the state. For example, if the diplomat of a state is committing an internationally wrongful act, if that diplomat is somehow involved in espionage or any other kind of activity against a state, so that is basically the organ of the state. Diplomacy is the organ of the state. So if the state's officials in their official capacity, if they are involved in any kind of internationally wrongful act, so that would be attributed to the state because they are working on behalf of the state. They are representing the state. They are the arms of the state, the organs of the state. So they will be, that is why the state will be held responsible for that act. Like for example, the foreign minister, the ambassadors, other government ministries and different departments. So they will be responsible. The state will be held responsible if these organs which I just mentioned, they commit some sort of an act against any other state, which then that will be termed as internationally wrongful act. And then the conduct of a private person or private entity is generally not attributable. If a private person like the individual, the citizen of state A is living in state B in his or her individual capacity, and if that person commits a crime, so that will not be termed as attributable crime to the state. That will be a private crime, not attributable to the state. The state will not be held responsible for that because he was in no way representing the state. So it will be like this. That is why, but then there are many ways in which the state can regulate the affairs of its private citizens even when they are abroad, like, asking its citizens to leave that country because there is kind of threat by that country that the citizen of state A would be wrongfully apprehended under wrong pretext and these kind of things. So that is why states can, if they can exercise, if they have the will, they can exercise their power over their private citizens as well who are residing in other countries. Then we have like a state is in a breach of, now what is the breach of international obligation? A state is in the breach of international obligation when conduct attributable to it is not in conformity with what is required by that obligation, right? If a state has an obligation and a conduct is which is attributable is not in conformity, like a diplomat is there and he is violating the diplomatic norms, this is now an obligation. There are rules and regulations for the diplomats, and if a diplomat is violating those rules and regulations in the host country, so then it will be a breach of international obligation by that state. It will be considered like that. Then the responsible state is under the obligation or under an obligation to cease the wrongful act if it is continuing. If that act is still continuing, then this responsible state or the host state, take the example of the diplomat again so that it will become easy for you to understand. This host state will be under the obligation to cease the wrongful act, to ask its diplomats to stop doing so, whatever they were doing which was objectionable, to stop them to do so. And then it is also under an obligation to offer appropriate assurances and guarantees of non-repetition of that act. So the state will also have to ensure, the host state, that these acts will not be repeated again in future by our citizens, by our diplomats, by our officials who are residing over there. Then the responsible state is under an obligation to make full reparation for the injury if there is an injury done. So this full reparation should be there. It should make full reparation, and it is the obligation of the responsible state. If some harm has been done to the host state by that diplomat, again I'll stick to that particular example so that it becomes easy for you to understand. Then what are the forms of reparation? There are three forms of reparation. Number one is restitution. Number two is compensation. Number three is satisfaction. So restitution, what do we mean by restitution? It requires that the state to re-establish the situation which existed before the wrongful act was committed. That is what we mean by restitution. Like, take the situation back to the pre-incident era where everything was normal. So the situation should be taken back by the home country in this regard. Then a state must pay compensation to cover the financially accessible damages, whatever have been done during that wrongful act while that act was being committed. So whatever financial damages have been done, so if those financial damages are accessible, then that state should compensate for it. And a state must provide satisfaction, which may consist of what? Acknowledgement of the breach, that yes, a breach has been done. That acknowledgement should be there by the state. Secondly, an expression of regret by the state should also be expressed or tendered or rendered to the host state that okay, a breach was done, that was a breach, we are extremely sorry for it as a state, and then a formal apology, like regret is it should not have been done, and then an apology, a formal apology. These kind of things should be, these are some of the forms of compensation, or some of the forms of reparation, not compensation, sorry. These are some of the forms of reparation. But if even all these things happen, then there are certain defenses available to the responsible states. And the big powers, they usually hide behind these defenses because their narratives are quite strong, and they usually hide behind these defenses. And what are those defenses? Number one is that they should have to establish that the wrongful act has been committed, but there was a context to that wrongful act, and the context was provided to us by the home state. And that is why this, by the host state, by the host state, and that is why the home state had committed committed these wrongful acts. Number one, what are the context? For example, we had a valid consent by the host state that you can commit such and such activities, and now when we were committing, so they term us as, they term those activities as wrongful acts, but they are not in fact. So this can be one of the pretext to that wrongful act which state B would consider as a wrongful act. Then state A, which would have committed a wrongful act, or the responsible state, can also say that whatever the responsible state or its official have done was purely done in self-defense. So then it will have to establish that there is a threat to our national interest, and we were just countering that threat. It was self-defense. So if it can establish that, and then force majeure. So this force majeure, it's you can call it like, you know, whatever was done was just, you know, the will of God. We had nothing to do with that. It was kind of a natural calamity. We were doing something in good intention, but then a disaster occurred, and you can hide behind these powerful states can defend their acts by these, that it was a natural calamity. It was what we call in Urdu faile khudawandi. So this was an act of God, and then we were just merely responding to it, and in the process we committed a wrongful act, but we were justified because we were just trying to counter that act of God, whatever that was, and it was a response to the natural calamity. But unfortunately that thing happened, and we are sorry about it, or it shouldn't have happened, but it happened. So it can also be, a state can also hide behind it. Then another thing is that we were just taking some necessary valid counter measures. So whatever the state was doing, the responsible state would say that we were just taking counter measures in response to their measures which they had taken. So that is why we cannot be held responsible, or the state cannot be held responsible. So these are some of the important aspects of it. Now there are many more aspects, but that is beyond the scope of this lecture now, because this is an introduction of international relations class. This is not an international law class, so that is why I will not be going in much detail about it, though there are many other aspects which I think are important, but even this much discussion on international law is this much of discussion of international law is enough for your understanding regarding the introduction to international law. But there is one important aspect which I must mention over here, and that is the role of International Court of Justice. So International Court of Justice is basically the chief judicial organ of the United Nations. All members of the United Nations are automatically parties to the statute of the International Court of Justice. There are many details about it. I will not be going into detail. If you have some ambiguity, then you can ask me, or in which kind of situations states can resort to the International Court of Justice, where is its jurisdiction, and what are the kind of activities of states which International Court of Justice can regulate, and whether states are supposed to ask the International Court of Justice, or the International Court of Justice has its right to take kind of a suo motu notice of regarding states issues. These are the issues which we can discuss in the class if you are interested in that, and if you are not, so we will not discuss that during the Q&A session. And if you are interested, you are a general viewer or even my student, and if you are interested about further discussion over this issue, so you can post in the comment, and then I will try to either address those comments in a separate video, or if the comment or under that comment. So I will try to do so then. Then if a dispute between the two states is decided by the International Court of Justice, so the decision of the Court of Justice, International Court of Justice, is binding on those two states, but it is not binding on the rest of the states. It will be only binding on the disputing states, only on those states who would have brought up that dispute to the International Court of Justice for some sort of decision. Further, this International Court of Justice has an advisory jurisdiction as well, and the United Nations Security Council and the United Nations General Assembly may request advisory opinion on any legal question regarding the International Court, or regarding any issue. They can ask about the advisory or opinion of the International Court of Justice, and they can also ask about the advisory opinion of many other UN organs, like what is the advice of WHO on such and such issue, what is the advice of UNHCR on such and such issue, what is the advice of UNICEF on such and such issue, or World Food Program. So it can or international IOM, International Organization of Migration. So these, the United Nations Security Council and the United Nations General Assembly, they can ask for the advices or the opinions of the UN specialized agencies and the International Court of Justice as well. So dear viewers and dear students, it was all about the international law or introduction of international law. I hope it would have helped you in at least developing a basic understanding about the international law. Inshallah, I'll meet you in my next video about another important and interesting topic of international relations. Till then, take care. Goodbye.